Well, good afternoon to everyone. This is Bob Dunlevey, and joining me is Nadia Lampton. We are attorneys at Taft Law. We wish to thank you for participating in our webinar on coronavirus and its implications for employers, being produced by Taft Law in conjunction with our host and friend, McGowan Brabender. We are bringing to you the most current information about state and federal legislation addressing the issues. For the next 50 minutes or so, we will discuss the labor and employment law implications and HR issues confronting employers and their employees. Questions and answers will follow, and as always, we will take a straightforward, practical approach to providing the needed advice to you. But please remember that this is a highly fluid situation. The laws and regulations are evolving each and every day. If you care to interpose a question at any time, feel free to do so, and you can also do it through texting Nadia at the address that is at the bottom of most of these slides. If you have not muted your devices so far, we'd appreciate it if you would so we don't get feedback. Needless to say, this declared pandemic and national disaster are presenting unique issues and challenges for union and non-union employers in all sectors of the economy. The phones are ringing off the hook, and we're receiving numerous calls about how to apply these new laws and deal with our workforces. So some of the issues we'll discuss today include the rights and obligations of employers to send home employees, the rights of employees to refuse to work and to collect benefits, the eligibility for state and federal unemployment compensation, paid emergency sick leave and paid emergency family and medical leave under the Families First Coronavirus Response Act, which was signed March 18. That's a mouthful. And in addition to that, the Coronavirus Aid, Relief, and Economic Security Act, also known as CARES, which provides, among other things, loans and grants, tax credits, and unemployment. And then we'll talk about the shutdown orders that various governors have installed across the various states, including the state of Ohio. And finally, OSHA's workplace safety requirements. These are the items on the agenda for the day. So let's get started. Here are the employment laws which are in play, and probably all of you are familiar with these, and you have worked with them in some manner in the past. Of course, the two that are new to the game are the Families First Coronavirus Response Act, and what does not appear there because it was just enacted Friday, March 27, is the CARES Act, and you'll hear from Nadia on those things. So turning first to safety considerations, let's talk about OSHA for the moment. There is no specific safety standard that actually addresses coronavirus in the workplace, and I guess you'd say, well, of course not. But we have some general principles to apply and some regulations that are in existence. And of course, the obligations that are addressed and are in play with these standards is first the employer's obligation to provide a safe workplace. And yes, the employer does have an obligation to do that under the General Duty Clause, Section 5A1 of OSHA. In addition to that, you have the obligation when providing that safe workplace to abate any hazards that may exist. And that's the second major responsibility of yours, which is the employer's obligation to eliminate recognized hazards in the workplace. So COVID-19 certainly is a recognized hazard. And so, among other things, you have the right to remove an employee from the workplace if the need arises, especially if there is reasonable suspicion or if symptoms exist. OSHA gives you that right. The removal of an employee also treads upon other laws, and if you are a unionized employer, and I know that most of you in the audience are not, but for those who are unionized, then the collective bargaining agreement can impact your rights to remove an employee. The takeaway here on providing a safe workplace is to train your supervisors to monitor your workforce and the signs and symptoms of coronavirus so that you may take prompt action to remove individuals from the workplace that need to be removed. The other takeaway is that you need to set controls in place at this very time. OSHA expects that of you. Social distancing, for example, and you've certainly heard about staying 6 feet apart. If you can do that, social distancing is part of a control that you can do. Deep cleaning of your facility periodically is another. The proper personal protective equipment, PPE, is another one. With respect to your actual facilities, you may wish to eliminate break rooms and lunch rooms for the time being and have employees either eat at their workstation, or eat in their cars, as the case may be. But I'm asking you to consider some controls to be put into place. Remember that if there is an actual diagnosis, you can certainly send the individual home, and we recommend that you stop work in the facility, or at least in that department, and decontaminate that department before returning the workers to the workplace. If there is suspected virus, you can send the employee home, and that is another approach that most employers are taking. There are no ADA implications to this, Americans with Disabilities Act. This is not discrimination on the basis of a disability because of special provisions that are in play, which I won't go into. So let's turn now to the employee's right to refuse to work and to travel. There is a section 13 of the OSHA Act that has to do with imminent danger or death or serious harm that may befall, and if an employee has a legitimate fear of such, they are not fear, but if they are actually placed in imminent danger, then they can refuse to work. But the mere fact that they have a general fear of contracting coronavirus is not sufficient to stop work, and this has been in play as late as just yesterday when Amazon employees in Staten Island engaged in a work stoppage, and some of them walked out. So be concerned about this type of walkout spreading to your place, and it certainly doesn't have anything to do with whether you're union or non-union. Remember also that employees cannot refuse to work from home generally, so if you give that option, they're obligated to do so. If you have a work site that maybe is not in the best interest of someone to be there because there is contamination of the virus, you certainly have the opportunity to transfer them to an alternate work site. So on this right to refuse to work, Nadia will talk about how the Labor Act is in play on this, and it's even that Labor Act is applicable, as I've told you in the past, to a non-union setting. The next frequent item that we're confronting is the employee's right to wear face masks. And if for avoidance if it's just mere avoidance that they saw it on TV and decided they thought it would be a good idea, you do not have to let the employee wear a mask. However, if the employee has some type of disability and the doctor recommends it, then we have the Americans with Disabilities Act in play, and once again, we'll have to perhaps make that accommodation. But remember, if you permit employees to wear masks in the workplace, you then have the respiratory protection standard invoked from OSHA. You know, OSHA's got a standard for everything, and it requires identification of the hazard and the training you're going to do and the listing of what kind of PPE you're going to use. And so if you trigger the use, you're going to have to create a program that's in compliance. And of course, there's conflicting information on whether masks actually are effective or not, and the debate is going on this very day. I heard it this morning before I left the home on national news. Turning now to the employer's right to test for virus and to take temperatures. This seems to be a popular item these days. You can't even find a gun to take a temperature in most places, and it's a popular question that we're receiving. The big question here is, Do we take temperatures? Don't we take temperatures? What temperature it has to be before we exclude somebody from the workplace? And then the real logistical question is, do we let the employees take their own temperature at home or when they come to work in front of us? Or do we designate a person from our management team, for example, to take the temperatures? And if so, then we're going to have to invoke all kind of personal protective equipment with respect to masks and gowns and face shields and other types of clothing, gowns. So if you don't go off to the races thinking you want to take temperatures right away and not recall that there's going to be some legal and logistical issues that are going to present themselves. Yes, you do have the right to take that temperature. It's an exception. It's the pandemic exception under the Americans with Disabilities Act. And if you do take temperatures, I suggest you do it in the least intrusive manner and in as confidential manner as possible. Can you compel someone to take a coronavirus test? Generally, the answer would be no, but of course, you could expel the employee until they take the test, at least in the non-union setting, so as to satisfy yourself that they're free of the virus. The final item on OSHA that we'll talk about is the OSHA accident logs. As you well know, for employers with 10 or more employees, you have the 300 A's and the 300 logs, which log accidents and illnesses. And so do you have to log each and every coronavirus incident because it's an illness? The answer is no, because remember that in order to log an accident or illness, you have to have the exposure come from the actual workplace. And it's extremely difficult to determine that it has happened. Of course, in a hospital type environment where a nurse would be exposed to an entire department of people with coronavirus, arguably that would trigger a reporting and requirement in that situation. I anticipate some additional directives from OSHA on many of these things, and they have announced that it's forthcoming, but they're a little bit on a slower track than some of the other agencies with respect to this. They already have some general information out that you may wish to pay attention to. So turning now to the National Labor Relations Act, it's Nadia Lampton.
Thank you, Bob, and good afternoon to all of our participants. I want to jump right in. We have a lot of material to cover, so I want to jump right into the National Labor Relations Act. As you know, some employer obligations under the National Labor Relations Act are limited to unionized workforces. But keep in mind that aspects of the National Labor Relations Act do apply to all employers regardless of unionization. Today, I want to discuss both aspects with you. So first, in a unionized environment, the rights of the employer are regulated by the terms of the collective bargaining agreement that's in place. Employers are obligated under Section 8A5 of the National Labor Relations Act to bargain over any new policies where there's a mandatory subject of bargaining involved, which means that employers with represented employees have a duty to bargain over any new policies developed to respond to COVID-19 if the current provisions of the collective bargaining agreement do not provide an avenue for those items to be addressed. So for example, if an employer wants to develop a policy on how to pay employees who are quarantined as a result of exposure or potential exposure, that policy involves a mandatory subject of bargaining, wages. And so it may impose on the employer a duty to bargain with the union. However, recently, the Labor Board accorded broader authority to make unilateral changes to collective bargaining agreements. Specifically, the Labor Board ruled that if an issue is within the scope or the compass of the existing contractual language in the collective bargaining agreement, only then can the employer escape the continuing duty to bargain. So what that means for employers is they have to look at the existing collective bargaining agreement for a relevant provision that would allow them to implement a policy. These provisions are going to be your management rights provisions, leaves of absence, paid time off, Any health and safety provisions that are in the collective bargaining agreement will also be relevant here. A broadly written management's rights clause may very well accord the authority to management to implement some of these policies, like sending an employee home temporarily, even in the absence of a more specific provision that would allow that under the collective bargaining agreement. Keep in mind that sending home employees for circumstances beyond the employee's control is arguably going to be considered a temporary layoff, and therefore the layoff provision of the collective bargaining agreement will come into play, and it will regulate when and for what reasons a layoff may occur. It very well may give the employer authority for a layoff based on safety and health reasons, but again, we have to look to the specific language. The no strike, no lockout provisions also address the rights of employees to stop work and the right of employers to exclude certain employees from working. Any management's rights and layoff provisions will trump the no strike, no lockout provisions. Also keep in mind that if the collective bargaining agreement does not contain a zipper clause, which forecloses negotiations during the term of the agreement, the employer might want to consider whether or not to compel union negotiations on a more expedited basis so that it can secure whatever rights it needs to deal with these circumstances. With that, I suggest to you that this should be a last resort. Management should look to their ability to send an employee home or implementing some of these policies to deal with COVID-19. Look to their ability within existing provisions within the management rights provision and others before resorting to reopening the contract. Also keep in mind that established past practice will have an impact here as well. If there is an established past practice, we'll look there as an avenue to address some of these issues. We have seen that some employers and union leaders have been amenable to working together to overcome the issues associated with coronavirus. One in particular, NECA, going so far as to enter a nationwide agreement that basically calls upon the management rights provisions and allows employers to take steps necessary now without going back to the bargaining table to give them discretion in handling some of these issues that are emergent and require a response immediately. While we expect that some other unions might follow suit, we're also seeing the opposite, and we're seeing increased information requests and bargaining demands also coming up here. So while some unions are responding to this in an amicable way with employers, others are a little bit more aggressive. On the point of union information requests, be on the lookout for information requests right now that's specifically related to an employer's response to coronavirus, especially in healthcare environments or work environments where the employees work very closely together. The main topics are going to include health and safety concerns and how absences or pay will be impacted. Likely those topics will be considered presumptively relevant as both are mandatory subjects of bargaining, and so the employer will be obligated to respond to those relevant requests for information. If you receive a request for information, you need to work closely with counsel to ensure you adequately respond. Just because we're in the middle of a public health emergency does not alleviate the employer's obligation to respond. And while we're all busy and we're all kind of taking a all hands on deck approach right now in dealing with this, there still remains that obligation to respond to those information requests, and failure to do so will result in penalties with the labor board. Similarly, be on the lookout for bargaining demands. Bob and I just saw this last week in full force and effect, where a union demanded to bargain, and the issues were related to the specific PPE that employers were implementing to keep employees safe, and also a request for hazard pay because the employer was an essential business requiring the employees to continue working, and so the union made a demand for hazard pay. So all of the provisions that we look to in the collective bargaining agreement to see how to address this, all of those are going to come back into play with a bargaining demand. So that is a very abbreviated and quick version of the National Labor Relations Act impact for the unionized operations. But I want to turn to the part of the act that impacts non-union employers as well, and that's Section 7 of the National Labor Relations Act. And Section 7 accords a broad right to employees to join together to advance their interests as employees and to take action regarding wages, hours, and conditions of employment. So an employee could withhold services, and that withholding of services or refusal to work could be cloaked with the protections of Section 7. And an employer's discharge or discipline of that employee, so discipline for insubordination, for example, could constitute an unfair labor practice under certain circumstances. Remember that even if only one employee refuses to work, it still could implicate Section 7 because it could be deemed concerted if it's determined that that individual employee is really bringing forward a group complaint or a concern that is common to a group of employees. So safety very well may be considered a concerted complaint that triggers Section 7 rights, even if only one employee is bringing it to the attention of management. So please keep that in mind. And as Bob said earlier, with respect to OSHA, the same applies here with the National Labor Relations Act, in that if an employer has remote work options, the employee would not be free to refuse working from home, assuming that such mechanism is in place. So employers really should assess their workforce now and their business needs now to determine whether remote work is an option for certain employees. And with that, I want to turn it back over to Bob to talk about some wage hour and benefits issues with you.
Okay, let's briefly talk about some compensation issues and some general rules and a few pitfalls that you may wish to avoid. The first order of business is to talk about compensable time. And as you know, the general rule is that there is no compensation for time off. So if the employee is at home not working, there's no obligation to pay that employee, absent some other special law that we may talk about here in a minute. Non-exempt employees who are hourly, are paid for actual hours worked. So you don't pay for the time at home when you send them home, unless they're working. And that's the issue. Compensation for home at work is an item that most people don't think about, but when they're at home answering phone calls and text messages and emails, that arguably is compensable time, and you have to pay them for that. So if you're going to have remote work arrangements, I strongly urge you to use a remote work agreement with the employees that set out the terms and conditions for such, and Nadia is going to go over that with you in a minute. Remember also that unauthorized, easy for me to say, unauthorized work is still compensable. And so when you have a situation where the employee goes ahead and does work for you at home, for example, and then they submit a time card to you, you cannot dock them pay for that because it wasn't authorized, but instead your only remedy is to discipline them for the unauthorized work. With respect to the exempt employees as opposed to the exempt salaried employees, those are your white-collar exemptions, usually executives, administratives, and professionals. It's a little trickier, but the general rule is that you have to pay those employees for the entire week, even if they work less than the full week. Less than a full week, perhaps because you sent them home because you're using some kind of staggered schedule or you had a lack of work. In those circumstances, the general rule is that that is compensable for the entire week. And no, you can't reduce the exempts to like 4 days per week and then prorate their salary accordingly. That cannot be done either. Let's turn now to PTO, FMLA, unemployment, and a few other items that are also, I'm sure, on your mind. PTO policies are not governed by all of these laws. PTO is a creature of contract. It's a creature of your handbook and whatever terms and conditions you may set. And there's different types of PTO. You know, there's the consolidated paid time off provisions where you bundle vacation days, sick days, and personal days together, tell them they have so many days and they can go out and use them, and if they don't use them, they lose them, or whatever your provisions may be. Many employers are utilizing their PTO and imposing an obligation on the employee to utilize the PTO during this period of time. And others are rewriting their policies to make PTO even more generous to give more time off. So the takeaway here is it's a creature of habit, a creature of contract, and feel free to modify and utilize your PTO as you see fit. The Family and Medical Leave Act, as we all have grown to know it since President Clinton enacted it, applies, to employers with 50 or more employees. The employee, to be eligible, has to have at least 12 months of service, and then you get 12 weeks unpaid with benefits. Now, that is changed with the family's first emergency FMLA, and Nadia will tell you how. But the takeaway here is to recall that the FMLA in its traditional form is still into play for those employers with 50 or more employees, and it can be used for the same reasons as it has always been able to be used for. But at the same time, remember that an employee can't go home out of a general fear of contracting coronavirus and try to somehow invoke FMLA on the basis it's a serious health condition when none exists. As to unemployment compensation, there is both state and federal unemployment compensation in play, and there's the special order of Governor DeWine that is making unemployment compensation easier for individuals to get. If the employer sends the employee home and to quarantine that individual, they're entitled to the unemployment. There is no waiting period now. And Ohio Jobs has the fact sheet out that'll tell you everything you need to know about that. Laid on top of that is the federal unemployment that's going to accord up to $600 additional benefits. So the unemployment benefits are generous and also are a consideration because there are some employers are going to try to manufacture ways to get unemployment in an effort to stay at home, and the compensation received may be almost as generous as if they worked. So you're going to have to watch the reasons that are announced for this and use your checks and balances. Workers' compensation is generally not in play here. Workers' compensation is for workplace injuries and illnesses. They have to arise out of the scope of employment, and generally that would not be the case here. Now, if it were perhaps an HVAC, a heating air conditioning person working in an emergency room of a hospital on a basis that they need some special work, maybe that individual could claim workers' comp because it's contracted, but in general, that avenue isn't available. One item I didn't mention on unemployment compensation is the shared work concept, and Nadia has written an article about it. Many of you have received a copy of it. That shared work concept means that you work the employee a partial amount of the week, and the balance of the week they can collect unemployment. It gives a little extra special situation so that they can still work for you and you can have some continuity at work. So it's we're getting a lot of interest in that. More than I ever thought we would get. Shared work concept, unemployment. Now, COBRA. With respect to COBRA, that is the insurance continuation. It's triggered by a separation of employment or a reduction in hours. You get 18 months of benefits. The employee pays the premium. This COBRA health continuation is still one that is applicable to all this, and most states even have a mini COBRA, such as Ohio. But the takeaway here is don't confuse COBRA Health continuation with the continuation of insurance under the Emergency Family and Medical Leave Act and the Emergency Paid Sick Leave provisions of the Families First law. And Nadia will go over that with you, but it's a different arrangement. The other thing that has come out of the insurance coverage item is that, as you know, and you have to be an active employee under all these policies in order to obtain the benefits of coverage. And an active employee usually has to be just that. They have to be active and at work. But provisions have now been enacted that deem these people who are off to be active employees so that insurance can go on without interruption. So that's good for the employers so that there's no difficulty in coverage. So we turn now to other considerations, and Nadia.
Thank you, Bob. So with the implementation of the state-based stay-at-home orders and all of the guidance from CDC and other public health officials, more and more employers have been resorting to remote work options, assessing their workplace and business needs to see which employees among their staff can work from home. And as a general rule, employers are not required to allow employees to work remotely, but as I said, under the circumstances, many have implemented remote work options and remote work policies. I suggest to you that it would be both legally and practically prudent right now, based on a number of business considerations, to consider whether a more flexible workplace policy could be implemented that would allow your employees to work from home. But if you do that, you must have a remote work policy that limits your liability and exposure as an employer. And you should contact legal counsel to assist you with that. I want to just give you some of the important provisions that those policies should contain. But again, these policies are not one size fits all, and they should be tailored to the employer's specific business needs. But these are the provisions that most policies will at least touch on in some form or fashion. The policy will include some built-in provisions on employer discretion and the employer having final authority for all decisions and determinations related to the remote work arrangement. The policy should outline the availability and the scheduling of the employee. So for example, will the at-home work hours mirror the employee's traditional schedule when they're in the workplace, or will they have an alternate schedule at home? Will they have the exact same hours, or will they be working varied hours throughout the course of the day? What communication expectations will be in place? Is the employee expected to return phone calls, return emails, things like that throughout the day? Whatever those communication expectations the employer has need to be put into the remote work policy. Establish parameters for the work environment. Discuss what equipment and supplies the employee will need to effectively work from home, and who's responsible for any expenses related to the working from home. Also outline any tech support obligations or lack thereof. One of the big issues, though, will be security. How will you and the employee protect proprietary company and customer information? You need to protect your confidential and trade secret information and your customers' information, even in a remote work setting. So largely, the policy will discuss security measures that need to be implemented. The other important provision that the remote work policy should contain is an expectation with respect to timekeeping. So especially if you're dealing with any exempt employees, if you want them or don't want them working at certain times, you can build that into the remote work policy so that the expectations are clearly outlined for both the employer and the employee. Some other considerations besides the remote work policy, although this should be contained within the remote work policy, but it applies outside of a remote work arrangement, and that is the protection of your confidential and trade secret information. Don't forget that if you have trade secret information, it is your obligation to secure that information. If you do not secure your trade secret information, you risk losing the trade secret protection. So while we are all in the middle of a worldwide pandemic, and things are a little chaotic right now, don't forget that you have that obligation. Don't throw out the security measures that you've had in place for some time. Don't throw those out the window. Try to, if you have to make modifications to how you secure that information due to either a remote work arrangement or some other factors, it's fine to change the way that you secure that information, but make sure you're still securing it. And that's another reason the remote work policy is good, because it has a mechanism for you to sit down and think about how exactly and practically you're going to maintain the high level of security for your trade secret information, because you're forced to put it in writing. So keep that in mind. Another consideration to think about right now is employee goodwill and your public relations image. Recognize that your considerations right now are not just business and they're not just legal considerations. If you're a business that's been forced to close your doors because of the coronavirus outbreak, don't forget that at some point those doors are going to open up again. And if you want your workforce to stay with you, consider how to act now to maintain employee goodwill. Similarly, how do you want the public and your customers to view you and your actions right now? Taking stark measures against employees to cut costs likely is not going to achieve the high marks in the public relations category. That doesn't mean that you have to do everything your employees want you to do or everything your customers want you to do right now. I recognize that you have plenty of business considerations to be thinking about and plenty of legal considerations, but I offer you employee goodwill and public relations as some other considerations just to think about as you're making these decisions. There are also contract obligations with respect to force majeure clauses, and I'm going to let Bob talk about those for just a second.
Turning to basic business contracts related to the supply of services and products. Many contracts have what's called an act of God or force majeure clause, and that clause basically excuses one or the other party from performing when there's an extraordinary event, an act of God, such as a hurricane, for example, or a tornado. And the issue that it presents itself basically is, may a customer void a contract for a reason that the act of God has occurred? Or may you refuse to perform the work because you don't have enough employees available? Is that an act of God? Is that covered by the force majeure clause that's going to give you an excuse to get out of it? And these clauses are highly specific how they are written, and they are narrowly construed by the law. So be careful about how they're written. Do you have to have a complete inability due to that act of God in order to walk away from your obligations? Or instead of a complete inability, is it just that it's inadvisable or commercially impracticable to continue to perform the services? Every contract is specific to its language, and you need to consult it. And to the extent that you're entering into contracts from this day forward, if you don't have a force majeure clause, maybe you want to put one in, as things could change and even get more difficult for you to perform. So there's the takeaway on some basic contract law.
Thank you, Bob. One question in addition to some of the other considerations on your slide. is whether or not some of these changes are going to impact the workplace on a more long-term basis. And it may very well be that the ramifications of these emergency actions are far-reaching, and some of them may be permanent in some form or another. The way that we perform work, the way we're giving time off and compensating for time off will change dramatically and may shape future decisions and future legislative decisions. Bob and I have discussed this at length, and it would certainly come as no surprise to us if after this public health emergency is over, we may still see more people making telework requests and asking to work remotely on a more permanent or a more routine basis. And so some of these workplace changes will have a greater impact on our businesses than just what we're dealing with today in the midst of the crisis. We also think that paid time off and these types of benefits we're seeing now may become an actuality on a longer term scale. So just consider that. It's just food for thought right now, but there are just some considerations we need to be thinking about. There's a bullet on your slide that says reasonable accommodations, and I put that there just to remind you about reasonable accommodations under the ADA. Bob touched a little bit on ADA considerations earlier with respect to your confidentiality obligation. So the idea that taking the temperature constitutes a medical exam, and so employers are obligated to keep that information related to the taking of the temperature, keep that information confidential. But there's other ADA considerations here as well, and that is that you need to be careful when faced with an employee request right now, whether that request is to work from home or wear a mask or whatever the request may be. I caution you not to prohibit the practice or the request out of hand. Don't assume right now that the request is because of the coronavirus. It very well may be, it very likely is, but don't make that assumption. If an employee makes a request, you should take the traditional steps you normally or otherwise would take to determine whether the request is a request for reasonable accommodation under the ADA, such that you're obligated to engage in the interactive process. If the request is one solely related to the avoidance of contracting coronavirus, then the request is not related to a disability and would not be protected by the ADA. But remember, you very well could have employees who have a heightened risk of contracting coronavirus or a heightened risk associated with complications of coronavirus with respect to an existing condition. And those individuals and their requests are going to be, will trigger some of these obligations under the ADA. So just keep that in mind. Right now, prevail upon common sense. Common sense is your friend. Don't throw away all of the traditional practices and the traditional analyses that you would otherwise undergo when you're faced with these requests and these issues. Some of these are very complicated issues, but don't throw away the practices that you've built up over a period of time in dealing with these issues. Keep those in mind. And with that, Bob is going to talk to you a little bit about the state-based stay-at-home orders that we've been seeing with more frequency throughout the country.
So up on the screen, you can see various states in some form of shutdown. The things move so fast that we're not able to add Arizona and Maryland in there. And since we started this conference, there's probably even more to add. And it certainly looks like a trend. I think the other trend is going to be that you're going to see these orders tightened, and I'm fearful that Governor DeWine is going to do so. But this one was enacted on the state of Ohio's was enacted on March 22, and seems like a long time ago, and went into effect on March 23, and it was Amy Acton, the head doctor for the Department of Health, that issued the order. you all know that basically it identifies what essential activities are, what essential businesses and operations are, and also lists certain tradespersons and businesses that are deemed to be basic services that need to continue in effect. The one item I want to hit on this is one that seems to pop up the most, and it has to do with social distancing requirements. And social distancing requirements pertain to the keeping apart by 6 feet. And you go to the grocery store and there's tape on the floor 6 feet apart at the cashiers. This is part of paragraphs 15 and 16 of that order. And we have employers coming to work saying, you cannot guarantee that I stay 6 feet apart from my fellow worker, and therefore you're breaching your requirements under the order of the Department of Health, and I'm going home and you're going to pay me all kind of different benefits. And the answer is no, that is not true. First of all, recall it in both paragraphs 15 and 16, they're using the phrases where possible or as much as reasonably possible. So social distancing is not an absolute at 6 feet, but we're hearing a lot of employees saying to the contrary. So that's the takeaway that you want to consider on the stay-at-home legislation. Let me look to see if there's any additional items I wish to bring to your attention on this. No, I think that's basically it for now. But stay tuned, because just yesterday, Governor DeWine did talk in terms of reconsidering the breadth of the order. And right now, it really isn't that onerous. It permits a lot of different operations to remain in effect. Nadia?
Thank you, Bob. I just want to take this opportunity before we jump into the Families First Coronavirus Response Act to remind you that my cell phone number and my email address are at the bottom of some of these slides. And if you have a question, please feel free to text or email me, and we will work your question into the presentation. I have already received a number of questions. Rest assured, Bob and I will address those in just a little bit to the extent we have not already. So hang in there with us, and we will address your question as soon as we get through some of this other material. The Families First Coronavirus Response Act, as you know, was signed by the President on March 18th. The Department of Labor issued some preliminary guidance to us in the form of legislative questions and answers and some fact sheets, but we do not yet have agency regulations, which will be very helpful in directing employers' response to certain issues and certain questions. So I must remind you, as Bob told you at the beginning of this presentation, that these are highly evolving issues, and we do not yet have regulations. So when we're talking about this Family First Coronavirus Response Act and some of your questions, right now we're going on initial preliminary DOL guidance, and they're not the actual agency regulations. So just keep that in mind. As soon as we get those regulations, we'll be sending them out to folks. But make sure that you, before implementing any action with respect to your policies or any action with respect to an employee request, make sure that you are basing those decisions on the most up-to-date information from DOL. The act will become effective tomorrow, April 1st, 2020, and covered employers must provide emergency paid sick leave, which I'll refer to as EPSL, and partially paid expanded family medical leave, which I'll refer to as EFMLA, for certain qualifying reasons related to the coronavirus emergency. Let's go to the next slide, and you'll see information related to the emergency paid sick leave portion of the Families First Coronavirus Response Act. This emergency PSL provides up to 2 weeks of paid leave for an employee who has a qualifying need, which is one of those 6 reasons listed on the slide. So an employee is subject to a government mandated quarantine or isolation order, or an employee has been advised by a public health or by a healthcare provider, to self-quarantine. It's also available for an employee who is experiencing symptoms and is seeking a medical diagnosis, or for an individual, for an employee who's caring for someone else covered under reasons 1 and 2. So the employee is caring for someone else who is subject to a government mandated quarantine or who has been advised by a healthcare provider to self-quarantine. And the big one that we're seeing a lot with is number 5, caring for the employee's son or daughter if the school is closed or the child care provider is unavailable due to coronavirus. And then 6 is experiencing any other substantially similar condition. With number 6, we're really not sure what that all encompasses at this time. We're really waiting for agency regulations to tell us a little bit more. But for now, there's not going to be much that's going to fall under number 6 because it's a condition that has to be specified by the Secretary of Health and Human Services in consultation with the Secretary of Treasury and Secretary of Labor. And since we don't have any guidance on what those conditions are yet by those agencies, there's that number 6 is not going to be triggered unless or until we get agency regulations. Keep in mind that fear of contracting coronavirus is not listed there. So an employee who comes to you and says, I'm afraid that I'm going to get the virus by continuing to work, I want to take 2 weeks off because public health officials are telling everyone to stay home, that is not a covered reason for getting the emergency paid sick leave. So that just doesn't cut it. Also keep in mind that if an employer allows an employee to take leave prior to the effective date, so prior to April 1st, for any one of these reasons, that employee is still permitted to take the full amount of time after the effective date. So if you've given someone leave last week for one of these reasons, starting tomorrow, assuming they otherwise qualify, starting tomorrow, they are eligible for the full amount of time. And if you go to the next slide, you'll see that the amount of time under the Emergency Paid Sick Leave Act is 2 weeks, equal to 80 hours for full-time employees or the number of hours a part-time employee would normally be scheduled to work in a 2-week period. The rate of pay will depend upon the reason for the leave. If an employee is taking the emergency paid sick leave for the first 3 reasons on the prior slide, so those are that the person is subject to a government mandated quarantine or isolation order, or they've been advised by a healthcare provider to self-quarantine, or they're symptomatic and they're seeking a medical diagnosis. For one of those 3 reasons, the employee will receive their regular rate of pay up to $511 per day, or $5,110 in the aggregate. If the employee is taking leave for one of the other reasons, so they're caring for somebody else, basically, then the employee will get 2/3 their regular rate, up to $200 a day, or $2,000 in the aggregate. I want to switch gears just a little bit and talk about the expanded FMLA leave. This involves up to 12 weeks of EFMLA, and it's for an employee who has worked with the company for at least 30 days, and the employee is unable to work or telework due to a need for leave to care for a son or daughter whose school is closed or whose child care provider is unavailable due to the coronavirus public health emergency. Note that the child care provider is someone who receives compensation for providing child care services. So if grandma or grandpa watches baby Susan and mom and dad don't pay grandma and grandpa any money, that's not going to cut it. That's not going to meet the definition of a child care provider. The first 2 weeks of the EFMLA are unpaid. But keep in mind that an employee can use the EPSL benefit simultaneously with the EFMLA benefit. So they could say they want to take the EFMLA, those first 2 weeks actually could be paid through the EPSL. So just keep that in mind. After those first 2 weeks of unpaid leave under the EFMLA, the additional weeks of leave will be paid at 2/3 the regular rate for the number of hours the employee normally would be scheduled to work during that time. Also keep in mind that any unused paid sick leave or EFMLA is not required to be paid out, and it doesn't carry over into another year or anything like that. If we turn to the next slide, I want to talk briefly about job protection. Keep in mind that employers must restore an employee to an equivalent position when they have concluded their EFMLA leave. There is a limited exception that applies to small employers with fewer than 25 employees. For those employers, they have to make reasonable efforts to restore the employee to an equivalent job unless that position was eliminated due to economic conditions or other changes in the operating conditions of the employer due to this public health emergency. But still, even if the job was eliminated, the small employer with fewer than 25 employees, that employer still has to make reasonable efforts to contact the employee for any equivalent position that later becomes available in the 1 year following the first day of the employee's EFMLA leave. Let's move on to the next slide and talk about the covered employers, the employers that this law applies to. The emergency paid sick leave and emergency FMLA has to be provided to all, by all employers with less than 500 employees. Separate corporations may be considered a single employer under the Fair Labor Standards Act, under their joint employment doctrine, or the FMLA's integrated employer doctrine. You should consult legal counsel if that's a scenario that would apply to you. There is a potential exception for small employers with fewer than 50 employees if providing the leave would jeopardize the viability of the company. But I caution you that as of right now, small employers are still required to provide the EFMLA leave. They're just not subject to civil liability for failing to do so. What the law does is it gives the Department of Labor authority to issue regulations that would exempt those small employers with fewer than 50 employees. And we have every indication as of right now that DOL is doing that, but that there are some specific conditions that have to be met, certain conditions that DOL is going to implement through their regulations. Right now, we only have them in the form of Q&As, but we anticipate that DOL will issue regulations that will specifically provide this exception. But for right now, they're still obligated to provide the leave until we get those regulations. But they would not be subject for civil liability for failure to do so. I want to turn to the next slide and talk to you briefly about enforcement. As I said before, the effective date of the act is April 1st, 2020. It goes through the end of the year, so through December 31st, 2020. There is an initial period of non-enforcement for the initial 30 days for employers who have acted reasonably and made a good faith attempt at compliance. There's a lot of questions that employers have right now, very fact-intensive scenarios, and they're not really sure whether or not, the paid sick leave provision applies, or how to apply it in certain scenarios. So right now we're doing the best we can without regulations, but this is a nice piece of the legislation for employers to keep in mind, that if they're acting reasonably, if they're making a good faith attempt to apply the law in a reasonable manner, they're not going to be penalized for the first 30 days, assuming that they're operating in good faith. And what that means under the law is that if they find out that they've been applying something incorrectly, the employee will be made whole by the employer, and that the employer commits to the Department of Labor that they're going to comply with the act in the future, and that the violation was not willful, but it was simply a mistaken application of the law. So as long as an employer is operating in good faith to apply these provisions, there will be a 30-day non-enforcement period. After that, there are some stiff penalties. They're going to be the same as the FMLA and FLSA. So violation of the EFMLA will be same as FMLA, lost wages and benefits, out-of-pocket costs, liquidated damages, attorney's fees, equitable relief such as reinstatement to the position. For violation of the emergency paid sick leave, it's going to be the same penalties that we see in the Fair Labor Standards Act, and those are listed on the slide. Let's jump into the tax credits briefly on the next page. The law provides for a 100% tax credit reimbursement for all paid leave. The amount matches the daily and aggregate payment caps that we've already talked about, so the $511 and $200 caps. And then there's additional tax credits available for health insurance coverage that the employer provides during this time period. How the credit is supposed to operate in a way that gives employers immediate access to payroll taxes that are withheld from employees to pay employees for the required leave under Families First Coronavirus Response Act. If those payroll taxes are insufficient, employers can request an accelerated payment from the IRS. I'm told that this takes approximately 2 weeks, but that they can request an accelerated payment from the IRS. And we expect IRS to provide additional guidance on the tax credits and claim forms within the next week. Keep in mind the credit is not available to state and local governments and political subdivisions. So just keep that in mind. I want to go to the next page because I think that this slide of frequently asked questions will answer many of the questions that you have related to the new emergency paid sick leave and expanded FMLA provisions. So the first is coordination with other leave policies. One question we've been getting a lot is, what if leave was already given prior to the effective date? As I said before, there's not going to be any credit towards those grants of prior leave. So it's only going to apply as of April 1st going forward. What if an employee already, what if employees already have paid leave available under an existing company policy? The EPSL and EFMLA are in addition to benefits already provided by the employer. The employer cannot require employees to use paid leave under a policy prior to using the EPSL and EFMLA benefits, although they can be used concurrently if the employee wishes to do so, for example, to increase the 2/3 pay to a full day's pay, something like that. We've been getting a lot of questions about intermittent leave. Can EFMLA leave be used intermittently? And the latest guidance from the DOL in the form of those legislative Q&As tells us that it can be used intermittently, but only if the employer allows for it intermittent use. Absent employer agreement to the intermittent use of the EFMLA, it will not be allowed. What about certifications? What certification can employers require? The Act is silent on this, so be reasonable under the circumstances. We expect DOL to issue regulations on the certification requirement. Employee and employer notice obligations. There are notice obligations for both under the Act. Employers are required to post a DOL poster in a conspicuous place where all employees can see it. So it shouldn't be put in a binder and shoved under someone's desk. It needs to be in a common use space in the workplace. Or if the employer has an intranet, that might be an effective way as well to post the notice. Employee notice is also required, and reasonable notice procedures are okay. So where leave is foreseeable, an employee has to provide notice of the leave to the employer as soon as practicable. We talked already a little bit about fear of contracting coronavirus. Fear of contracting the virus is not a covered reason for paid leave. The next subject is the maximum FMLA and EFMLA leave. Keep in mind that we combine the FMLA and EFMLA taken within the last 12-month period. So the EFMLA, the amount of leave that an employee can take, will be lessened by whatever traditional FMLA they've used in the 12-month period that the employer relies upon. And the FMLA, the traditional FMLA can still be available right now for other reasons, like the employee's own serious health condition that's not related to coronavirus, or caring for another family member with a serious health condition not related to coronavirus. But that leave is not paid. You're gonna follow your usual procedures with applying regular FMLA. Record keeping. This is a big one. So, and we've been getting a lot of questions about record keeping. And we don't know all the answers, again, because we don't have regulations. But here's what we do know. Record keeping is a requirement. So the employer is going to have to insist upon documentation to substantiate the need for leave or for the paid sick time. What the specific documentation is kind of up in the air right now and up to employer discretion unless or until we receive regulations that specifically outline this. So I've received a question from someone today already, how do we document for paid leave? So for example, if you have someone who is symptomatic and they've taken a test or they're awaiting testing, you need something from the healthcare provider that says this individual is symptomatic and they are awaiting test results such that it would trigger one of the reasons for the paid sick leave. Similarly, with an employee who wants to use EFMLA to take care of a child, we need something indicating the need to take care of the child. So a notice that the school is closed, an email to parents saying the school is closed, something like that. Now we get into a little bit of a gray area here where the employer knows that a spouse is also at home, and so then the question becomes, is there really a need for leave to take care of a child? If you have one of those circumstances, I would consider consulting counsel to talk about some of your options there. With the government mandated isolation order or quarantine, keep in mind, and I think Bob addressed this a little bit earlier, we don't think that the stay-at-home orders constitute a government mandated quarantine or isolation order. That's based on the most recent guidance from DOL, but that is subject to change if we get regulations that take a stricter or take a broader interpretation of the government mandated quarantine or isolation orders. Also keep in mind that employers, for multi-employer CBAs, they can fulfill their obligations by paying into a multi-employer fund, program, or other plan the amount equivalent to the paid leave required by the Families First Coronavirus Response Act, as long as the employee can secure some sort of payment from that fund, program, or plan. And in that case, you follow the plan and bargaining requirements. I don't think that this multi-employer CBA provision will apply to very many, if any, unionized employers. At least I have not seen any provisions that would trigger the multi-employer provision of the Families First Coronavirus Response Act, but it is there. I want to turn next to the Coronavirus Aid, Relief, and Economic Security Act, more commonly referred to as the CARES Act. I'm going to spend just a minute or two on this slide, and then we'll turn it back over to Bob and we'll take some of your questions. The CARES Act was signed by the President on March 27th. We have no guidance or regulations, though, on the CARES Act as of yet. It provides $2 trillion in direct financial assistance to Americans, but it also provides several programs and interventions to provide financial relief to eligible employers and employees. There are small business loans that are available to eligible employers, but I caution you to be careful because there is a union neutrality obligation within that. So employees who want to take advantage of the small business loans have to agree to remain neutral in any current or future union organizing campaigns during the life of the loan. There are also enhanced unemployment insurance benefits under the CARES Act that enhances the unemployment insurance benefit availability for employees for total and partial unemployment, and it gives employers some credits for retaining certain employees. The CARES Act also confirms that the EFMLA and EPSL provisions of the Families First Coronavirus Response Act will have tax credits available to employers, and it provides confirmation that employees laid off after March 1st and then are rehired will still be entitled to the EFMLA and EPSL provisions. And it also provides funds to federal agencies for federal contractor leave in certain cases where job duties can't be performed remotely. The CARES Act also has a component of federal government loans to certain distressed businesses, but in those cases, there's limitation on compensation paid to executives of businesses that are subject to these loans. And then it also provides non-taxable qualified disaster relief payments. That is a very broad overview of the CARES Act. There's much more to it, but for the sake of time, I'm going to pass it back over to Bob, and then we will address some of your questions. Bob? Bob, are you with us?
Thank you. Good job, Nadia. The next slide shows a Legally Speaking article, and many of you receive our periodic publications. This one happened to be one of the first ones that we issued, and it's been updated with respect to coronavirus. And if you're not on our mailing list and would like to do so, please feel free to text us, email us, and we'll be happy to get you on that list. I have been told during the course of this presentation that over 800 people have attempted to access the presentation, and the software only permitted 500. So we maxed out. But this is going to be recorded and provided to David Homan at McGowan Brabender, and it's going to be disseminated and available. So you can spread the word if one of your cohorts didn't get it, that it's on its way. We'll turn now to questions, and Nadia, you're the keeper of the questions, so go ahead.
Thank you, Bob. I will tell you I've received in excess of 50 questions. We are not going to be able to, we're simply for the sake of time, we're not going to be able to address all of those questions. So I'm going to pick just a few that are, seem to be the ones that I've received more than once or from several of you, and we will address those. And then after that, you have our contact information and you can reach out to us. We will try to put together a comprehensive Q&A after this that will address some of those, but you certainly know how to get a hold of us. So for the first question, is there a form for employees requesting leave, or do we create our own? There is not a specific form right now. DOL may issue one, but we do not have one as of right now that is from DOL or from IRS. However, Bob and I have created one, and we are happy to provide it to you. If you reach out to us, we can provide the form to you. Next question, and it's a hypothetical. If an employee is sent home by the employer because the employee was exhibiting symptoms of coronavirus, is the employee eligible for the paid sick leave? The answer to that is that if the employee was sent home by the employer because they're symptomatic and that's the end of the story, then no, they're not eligible for the paid sick leave. We need some sort of directive, some sort of order from a healthcare provider that the employee needs to self-quarantine. And that's not going to be too terribly challenging for the employee to get for you. I'm told that there are remote ways for the healthcare provider to provide this information. So if the employee contacts their healthcare provider and goes through some of their symptoms, it's likely the healthcare provider will provide that directive telling them to self-quarantine. And once the employer receives that documentation, then the employee would be eligible for the paid sick leave.
If you recall, when Nadia made the presentation, item 3 of the 6 reasons for the sick leave is experiencing COVID-19 symptoms and is seeking a medical diagnosis. So there's a little more than just going home with symptoms.
Thank you, Bob. The other question I've received from several of you is, what about high-risk employees? What about employees who have some sort of disability that puts them at a high risk for complications? And what I would say to that is that if you have an employee who has a disability that puts them at high risk for complications with coronavirus, those employees may request to work remotely as a reasonable accommodation to reduce their chances of infection during the pandemic. But note that that obligation is triggered by the employee's disability. It's not triggered by the coronavirus pandemic or outbreak. It's triggered by that employee's underlying disability. If an employee has some other stated condition like a cold that is not a disability under the ADA, and would not require the employer to engage in the interactive process. Also remember that if you have an employee with a disability who has asked for an accommodation, you're not obligated to accommodate the employee through his or her own choice of accommodation. If there are multiple potential ways to reasonably accommodate the employee, the employer can select the accommodation that best suits their business needs while also accommodating the employee. So keep that in mind. But employees with disabilities that put them at high risk for complications, they can request to you to telework or remote work as a reasonable accommodation to reduce their chances of infection during this pandemic. But again, I would remind you that is with respect to their underlying disability and not with respect to the coronavirus in and of itself.
Or a general fear of contracting it.
Right. Another question we received is, how does short-term disability coordinate with the emergency paid sick leave? Does it kick in after the emergency paid sick leave? And there, yes, whatever existing benefits you offer, a short-term disability benefit, for example, the employee can use it. The employer cannot require that the employee uses it, but if the employee wants to use the short-term disability, they can. It would kick in after the emergency paid sick leave. If you have any sort of waiting period or anything like that, that would still apply. You're going to look to the language of the policy for implementing that policy. The Families First Coronavirus Response Act doesn't change anything with respect to those specific policies. I'm just looking through some questions here. One question, what if an employee was concerned about continuing to work, so we laid that employee off? Is that going to be considered an adverse action against the employee? So now we're into a little bit of a gray area. This is going to be a very fact-intensive analysis, but kind of broad strokes. If the layoff was because of the employee's safety concern that he or she expressed, then yes, that's going to be considered an adverse action, and it could trigger Section 7 of the National Labor Relations Act. If the layoff was because of, some other reduction to your workforce because of economic reasons that are related to coronavirus, then no, that may not be considered an adverse action triggering the National Labor Relations Act under Section 7. But again, this is a gray area. It's going to be fact intensive. There's going to be far more questions that Bob or I would ask you if you called us and asked this question over the phone.
One item on this is that I know that some employees are requesting that they be given a layoff, and then it's up to the employer to determine whether they wish to do that or not. But if you categorize it as a layoff given by the employer, then there's going to be consequences that follow. For example, under the emergency unemployment compensation provisions, if you send the person home, that's going to trigger the entitlement to the unemployment compensation benefits, both state and federal. So there's some implications there. And the other thing is that this presentation was given today on the eve of the act going into effect, because some employers who have been considering bona fide economic layoffs are considering whether to do those on or before the end of the day. And the reason for that is that if the individual has been laid off, then the entitlement to EPSL and EFMLA is no longer in existence. So employers are pondering issues about layoffs this very day.
Okay, another question is, we know Ohio schools are closed. What additional information would be needed for that? A public newspaper or a website posting would be sufficient documentation at this point to substantiate the triggering of the EFMLA and would substantiate the need for leave as of right now. The only caveat I would say is with respect to a related question that someone asked, and that is, can both parents request and receive EFMLA? Absent Department of Labor regulations that provide more clarity on this, the answer would be no, both parents couldn't receive the EFMLA at the same time. And the reason for that is because the triggering of the EFMLA is based on a need for leave to care for a child because the school is closed. If one parent is home with the child, there is no longer a need for the other parent to take leave to also care for the child. Obviously, that analysis is complicated if there are perhaps multiple children or children with special needs, that sort of thing. But you're really going to have to analyze whether there's a need for leave. It's not simply because school is closed, but it's that there's a need to care for a child. And if one parent is home, it's unlikely that the other parent has a need to also be home to care for the child.
And also the employer may be even going back so basic as to determine whether they're going to request proof that it is a son or daughter. Now, the term son or daughter is broadly construed under the existing Family and Medical Leave Act, and that same definition is being used on the Emergency Family and Medical Leave Act. But there's a threshold question about whether we actually have a son or a daughter here, and also perhaps some issues on whether we have a custodial parent or not.
Okay, so one other question, and then I think we're going to end the presentation. We'll have this presentation, as Bob said, available to you, and we will be available by phone or email to assist you with some of these issues should you need our services. But I want to end with this question. Our biggest gray area revolves around employees wanting leave due to having someone at home who's high risk. It doesn't fit neatly into one of the qualifying needs. What are your thoughts? And there, again, several of these scenarios go back to needing documentation from a healthcare provider. So if there's someone who is at home who's high risk, if you're trying to get this person to qualify for the need, the directive would be that person at home who's high risk needs to contact their healthcare provider and get documentation from the healthcare provider that that person, because they're high risk, needs to self-quarantine. Once that person's been advised by a healthcare provider to self-quarantine, then somebody else can theoretically qualify for the paid sick leave if they are caring for that person. Absent that type of a scenario and absent that kind of documentation to substantiate the need for leave, the employee who comes to you and says, my mother lives with me and she is high risk, that alone is not going to trigger any of the qualifying needs for the emergency paid sick leave. There has to be something more. There has to be a directive from healthcare provider that that person needs to self-quarantine, and then there has to be a need for the a need for your employee to care for that individual. And those items are going to need to be substantiated with documentation. And so that's what you're going to need in order for that employee to have a qualifying need under the emergency paid sick leave. And keep in mind, the emergency FMLA is only applicable when when an employee is unable to work or telework due to a need to care for a child whose school is closed. So that's the only qualifying reason for the EFMLA. And with that, I'll turn it over to Bob for concluding remarks.
Thank you. On behalf of McGowan Brabender, we appreciate your attendance and interest today. If we may be of service to you, or if McGowan Brabender may assist you in some of your issues, we all are here to help you, and please don't hesitate to do so. Thank you, and have a good day.